there are those who say, like he began, you know, that even the matter of the interpretive jurisdiction of the Supreme Court is an issue that ought to be determined by the court. So the court cannot make the determination without hearing the matter. And the court has done so upfront.
It's his view, and I disagree. It depends on how the matter comes. And if you read Article 2.2, there's a future tense there. It says, as it may consider appropriate for giving effect, that is immediate, or enabling effect to be given, that is future tense.
To what?
To the declaration so made.
Which declaration?
So I'm coming.
He's telling you the declaration comes after you have finished the case.
I hear you. I'm developing my point. No, wait. Listen to the Supreme Court's own reasoning.
Right.
They are faced with an ex parte.
And please, I don't say I share his view.
Of course, I understand.
Because when I play the devil's advocate, 2 minutes and people confuse it with an opinion.
You see, this thing...
I'm ready to take opinions, alternatives. Thank you.
I wish we didn't have to debate it outside.
Right.
Because really, when sometimes people behave as if there's an answer and they know it, I think it's not really the best.
The problems of
things
confirmation bias.
Yeah, you know, simple things, it's important. Simple things like the fact that all men were born equal. And war was fought over it in the US. Okay? And before they got the Magna Carta, to get kings to appreciate that all men were equal, they had to fight a war. So now we take it for granted that these things...
Back to Article 2.
So back to the point. Here's the thing. You are the Supreme Court. There are a number of things that we all should agree on, and we'll proceed from there, because those ones are not controversial. Number one is that the Constitution is supreme about everybody and every institution. We agree.
Correct.
Two, the Supreme Court is the only body that may interpret the Constitution. We agree.
We agree.
Correct. So whenever there is an issue that has to do with the interpretation of the Constitution, the Supreme Court takes precedence. Now, they are then faced with a situation where somebody comes ex parte, which means they come alone without the other party.
They come on the blind side of the other party.
However, I'm speaking to the general public, alone without the other party. So the other party cannot make their case before the Supreme Court. We all know that when that happens, what the Supreme Court or any court does is they listen to you and they will judge whether the situation is so exigent that they must make some sort of interim order. Interim. And the rule says the order should be up to 10 days. Note, I'm speaking as to what the Supreme Court was facing. Now, then make an order and say, we are giving you 7 days to come back. And the other people should also come back and file their papers so we will hear their side. It's within 10 days. Now, the Constitution gives them power that in terms of making those orders regarding these matters, they should be able to make all orders that help them to make a declaration and, you know, follow through to make sure that the proper thing is done. Which is why they were telling you that they have the right not to say 10 days, but then they have given you 7 days, and if you obey it, you will come and they will deal with it within 10 days. Look at the other side. What if they chose not to come? Okay? Then you realize that if Parliament chooses not to come, okay, or disrespects the Supreme Court, then you realize that it doesn't even matter whether you give them 10 days or not, it won't happen. You must know that they are not called Supreme Court for nothing. And they don't only rule on strict law. There are policy issues and all kinds of things. One of the things we must also appreciate is this. If you disagree with a court, especially the Supreme Court, whoever you are, you must respect their ruling, give effect to it, and then go back to them.
Has anybody disrespected their ruling?
I am making a general point, which you agree with, right?
No, it's part of the thing out there in the
I made the point first. Can we agree?
Has Parliament disrespected it?
I'm not answering your question. I'm saying, can we agree that even if you disagree with a court, you must give effect to their ruling and go back to them?
I've repeated that many times here.
Thank you very much.
Ex parte affoda.
So if you're asking me whether
even if the decision is wrong, even if it's unlawful, if it's unconstitutional,
yes,
you must obey until you have set it aside.
Thank you. So the proper thing should be that Parliament should have given effect to that ruling and then gone back.
Has Parliament failed to give effect to the ruling?
Has Parliament given effect to the ruling?
You answer my question.
No.
Has Parliament failed to give effect to the ruling?
Has Parliament given effect to the ruling? No. You are asking whether that's...
What does it mean to give effect to the ruling?
To positively act to implement it.
How?
You make a declaration that some people have vacated their seats and therefore do not belong in Parliament more or less anymore.
The declaration has been suspended.
So you make a declaration to reverse it.
Really?
And no, wait. Like I'm saying, we are speaking to the general public. Today, as we speak, we know a declaration has been made by the Speaker, and he is the Speaker. Once he makes a declaration in Parliament, it is law. So, to the extent that the Supreme Court has said, per the Constitution, I want to hear you. So, in the meantime, suspend this thing because it has grievous, significance. You should reverse that thing.
Really?
Hold on. Just hear me. You should revert to the status quo.
How does the status quo revert? They say the decision is suspended. It means the 4 MPs are entitled to go to Parliament.
I hear you.
It means the 4 MPs are entitled to sit in the House and vote.
Correct.
It means the Speaker or no other person in Parliament must try to prevent them from entering or doing their work.
Correct.
Have they done any of these things?
So here's my answer to it. You are saying, therefore, that when the Speaker has made a declaration to the hearing of the whole country.
And it has been suspended.
Can I finish? And the Supreme Court has suspended it. It should be taken by everybody, including the Speaker, that the declaration that he made is withdrawn. And therefore, the status quo ante is back. That is what you are saying.
It's not withdrawn, it's suspended.
It's suspended. And so the status quo ante is back. They are all parliamentarians.
That is so.
I am simply saying that, you see, what you are saying is what will lead to confrontation, because somebody will sit in Parliament and say, having heard the Speaker say that it is no longer...
That is the person who would have breached the court's orders, correct?
Yes, but hold on. Samson, listen. So I'm saying, in respect, okay, or with respect to all these principles that the Supreme Court interprets the Constitution and says this and this, the Speaker should say, having heard them, please, the status quo is back. Then we are clear. Then nobody goes to do anything funny. Then, when the Speaker, is the Speaker of Parliament, sends his application into Parliament, even the tone of the application, the nature of the words, how they are put, will give an indication whether you are respecting or you accept the ruling or not. And you and I, we've made appeals and reviews. Even though you don't agree with them, you give the impression that I am respectful of your order, however, these are my views. I sincerely believe.
In appeals?
Yes. You can absolutely disagree with them and say these are my views.
And that's what you do.
But you don't give an impression that I don't respect your view, okay, and I'm not going to give effect to it. Please change it.
That's what you do when you challenge a decision of the court.
Then you are not getting what I'm saying. What I'm saying is when you are challenging the court, you are saying
when you are challenging a court's decision, you actually say that the court is wrong. Yeah. So what is wrong with them saying that before the court?
I don't respect is different from I disagree. I'm saying the tone.
If you don't disagree, how do you proceed?
You're not getting me. I'm saying we all respect and give effect to even rulings we disagree with.
The tone of the application was problematic?
You are not hearing me or you are not listening to me.
That's what you're saying. The tone of the application was problematic.
I am making some points, and the points I'm making is
that you were wrong. The law we know is that if it is ex parte, it must be for only 10 days. Then they come and say, that's not what we are doing. This is the other way we are going around it. Say you are wrong. You said we didn't give a hearing to the MPs. You also didn't give us a hearing, and you went ahead and made the order. What's wrong in that language?
I am simply saying, as we speak today, there is no express indication that Parliament has effected the ruling of the Supreme Court.
Must there be anything to show that they are effecting the respect of the Supreme Court? Why?
Why not?
When you do
when the Supreme Court gives you an order, when you have given instructions that have an effect, okay,
in practical terms, in your practice, when something has happened and some aggrieved party goes to stay execution of what you have done, do you do something to undo anything?
Until you stay it.
No, do you do something to undo something?
There are times you have to.
You don't.
There are times you have to.
When they stay execution, you just... It has been stayed, so you sit back.
When you are injuncted or when there are rulings made against you, you have to take actions in pursuance of them.
Really?
Yes, there are times. My point is this. You are saying...
You are doing something. When you are injuncted to stop, you simply stop. Is that not it?
So, simply stop. There are omissions and commissions. What I'm saying is this. You are saying that they should go to parliament and exercise their rights as parliamentarians, and until somebody stops them, then no evil has been done. And I'm saying that you don't wait for somebody to go to parliament to try and act as a parliamentarian representing their people, for somebody to stop them. You have seen the belligerence in parliament and how people have said that they were going to defend their majorities properly.
I need just a little...
You have been told that some people say they will resist this thing. You want them to resist it in parliament, where we have seen fights before. What stops the speaker from giving the signal that, having received this instruction from the Supreme Court, the status quo is held as it is? Meanwhile, you hear, all kinds of things being said about how the speaker does not accept what has been said.
How do you hear it? Why don't you want to hear the speaker when he speaks to you publicly?
I want to hear the speaker
when he speaks in parliament,
communicate his acceptance and communicate the fact that he does not agree.
The speaker, when he did the adjournment, what did he say? He said that he has become aware of, he's been served with this process, correct? That's what he said.
He refused the service.
No, he didn't. That's before. That's before his ruling. Not after his ruling. When they came back, when they reconvened, the day that the MPP refused to go to the House because the NDC were sitting at the majority side, he said that this has been brought to him. And that the NDC was the only group in Parliament. That group had the 92 threshold that you can do at business, but they didn't have half that you can do, take a decision. So he adjourned. He didn't adjourn because he's disrespecting Supreme Court. Is that not correct?
Okay. I'm also making the point that at the earliest opportunity, I believe what would inure to the peace and calmness within our leadership would have been for the speaker to say, I disagree with the Supreme Court, but I have received this order from them. And therefore, that order that I gave, vacating those seats, is suspended. And I'm saying he hasn't done that.
But it's suspended. He doesn't have to say it.
No, you keep saying he doesn't have to say it. And I keep saying I think he has to say it. And my reason for saying so is that I have heard people belligerently, even some angrily, saying they will defend their newly won majority. I have heard, we have all heard, people say they are going to use their majority to repeal laws.
Yeah, they have said so.
They have said so many things that they are going to proceed to do. Not once, not twice, not three times. And you think under those circumstances, we should assume that they are going to go in and do everything properly, okay? And you want there to be a scaffold, somebody stopping somebody physically or otherwise, before they go to the same Supreme Court again for rulings. When you have a state in this situation, that's why I said there are things we agree on. One of the things we agree on is that you can choose to disagree with the Supreme Court.
Why should the speaker announce a reversal when the case has not been heard to determine that he's wrong? Because the court has not made that determination. Because
he has been injuncted per the ex parte ruling that was given. And the ex parte ruling that was given, like you're saying, they should have ruled then. If they are ruled, then you will sit here and say, without hearing the other side, they passed. No, you didn't say that. Okay, you didn't say. Sorry, I withdraw it. I'm saying some people are saying they should have ruled on the ex parte. Okay. My point is, an ex parte is a one-sided motion. The Supreme Court says the other side, come and let me hear you before I rule. Okay. And until then, keep the status quo as it is. And I'm saying the simple thing that would have been done for everything to cool down would be for the speaker to say, I disagree with you. But because you are the ones that interpret the Constitution, and even people were saying that this is not an interpretation issue. So as far as you are concerned, the speaker is a problem. As far as I'm concerned, I think the speaker has not done what I believe would have led to greater peace. Greater peace. Yes. Okay, so we'll be right back. All right, so guys, you don't look at it that way. I just do what I have to do. I wish we were doing this off air. Then we'll get through it. So you know that the Habitat Fair is ongoing presently, and you are all invited to be at the Accra International Conference Center. Get a house, make it a home.
And there are several other things that you can get, and the Habitat Fair is still ongoing. I've got some messages from you. Let me share quickly, and we're supposed to take a quick break, do we? This one says that, I like the way you are interrogating Kofi. We can all diplomatically correct the blunder with bringing the Supreme Court or Parliament down, but insisting on both sides to respect the Constitution, procedures and consistency needed for justice to be seen. This is why are they not questioning the act and intent of the act of the Speaker, which has gotten us where we are? Should the Speaker be left on the loose to do all and everything at his whim? Was the Speaker's action not intended to achieve a political purpose? Right, so those questions continue to be asked, and people ask, what did Michael Okoye do? How different is that? This one says the constitutional duty is rather on the MPs to vacate the seats. No one needs to vacate them. Did the CJ or anyone else have any evidence that these 4 MPs haven't already vacated their seats? Have these MPs occupied their seats since they allegedly put themselves in the prohibited situations?
You should give me 1 minute to deal with that.
This one says that what Kofi Bentil is trying to say is that the Speaker, having acknowledged receipt of the decision of the Supreme Court on the floor of Parliament on the day he adjourned, should have informed parliamentarians that by virtue of the decision of the Supreme Court decision, the 4 MPs affected are to resume their duties. Okay, thanks for that. I'll take a very final message because my production is just pushing me to end here, because that is where
you need to give me a minute
I can end. This one says, when the Supreme Court asserts that it has authority to extend a stay in an ex parte application beyond the standard 10 days, one must question the legal foundation of such authority. Likewise, when the court claims it has jurisdiction over a matter, it is necessary to identify the source of this jurisdiction. The Supreme Court jurisdiction should only be engaged upon the filing of writs concerning determination that contravene the law. At the time of Afenyo King's filing, had the Speaker issued any rulings? Okay, so that was a no, and that's what some disagree with. Unfortunately, my production tells me that our time is up and we have to end here. How abrupt, but thank you very much. It's been Newsfile.